Good afternoon, everybody. Andy Bobrek here at Schoeneck King. Glad to have you with us. Hope you're doing well. Hope that your operations continue to do well in the current environment that we're facing with COVID and the challenges that are out there. Again, we remain incredibly impressed with your resilience and dedication to face what are some unique challenges and a very dynamic environment. And in that regard, today we're going to talk about a new piece of legislation that the state enacted, the New York Paid Sick Leave Act. We have touched on this on our weekly webinars. Dealing with COVID, we received a lot of questions, really many questions on this. And there's a lot of interest that we sense from our clients and our friends at the firm. So we wanted to do a specific outreach on this. Today, you'll hear from me, of course. We have another one of our all-stars, Teresa Rusnak, will be joining us too. Teresa, great to have you. Teresa's been tracking this legislation very closely, knows it front and back, and has been doing a lot of outreach as well on this. So it's great to have her with us. Just to get things started here, why don't I give you a little overview on what we'll talk about. And again, please feel free to submit questions using the usual means provided through this Zoom program. We'll do our best to answer those. I guess just as a side note, we tried to engage you beforehand to have you submit questions. We got a lot of very good questions. We've incorporated those into the presentation, and we'll address those questions and try to answer any others that we have. But keep firing away. We look at them. And I'm sure this will not be the last outreach that we'll be doing on the paid sick leave legislation here in New York. So we really appreciate getting your feedback on those. We'll give you an overview on this. I know some of you are probably familiar with the legislation already, including some of the nuts and bolts, but based on the questions that we're getting from clients and the interest, there still is a need for general education on this point. So we wanted to be sure to cover that. So we'll cover those basics. Some of the particular unique issues that we run into when it comes to having a current policy on the books. What do you do with that if you're already providing leave to employees? How do you account for the new requirements of paid sick leave? What if I have a bargaining unit and a labor contract in place that provides certain types of leave and other benefits? How does that dovetail with the requirements that we have under the new law? And then we'll talk a little bit about some of the other sick leave laws that are out there, very briefly on that. And Teresa will focus on those areas as well as the documentation issue. What kind of policy do we need to have? Do we need to have a new policy? Do we need to revise our current policy? What do we do when someone requests leave? Can we require them to provide some type of documentation on the need for leave? So we'll talk on that too. And then, as I mentioned, we also reached out beforehand to try to get to some of your questions in advance. We've listed several of those. Again, we got some great questions from people. We've listed several of those, and our plan is to go through those and keep this to the usual 45 minutes or so. But again, fire away with more questions if you like. So the legislation is the New York Paid Sick Leave, and we'll push out a link to the actual legislation. It's not hundreds and hundreds of pages. It's 3 pages. We'll get you a link to that, and we'll try to do it during the course of this webinar. If not, we'll send it out so you have a copy of it. It's not a bad idea to keep one handy. But this passed as part of the state's budget back in April. But the legislation itself was actually introduced and drafted back when really the coronavirus hit, and we were in the initial chaos of dealing with everything, and was attached to the state legislation that provided the emergency sick leave when, under state law, when an employee is subject to a governmental quarantine or isolation order. They had tacked this legislation more generally providing paid sick leave onto that, but eventually dropped that off, presumably because there was just going to be too much at once for employers to digest. So they waited a couple months and then passed the legislation as part of the budget. Expressly, it was modeled after the New York City paid sick and safe time legislation that's been on the books for some time now. For those of you with operations or employees in New York City, you're familiar with this already. That it was modeled after that legislation is notable in a couple different ways. It may help us fill in some of the gaps. Just as an observation from me, the New York City legislation was, I'd say, a little more robust in terms of how it defined terms, how it explained requirements, um, explaining who is not covered, what exemptions there are. And I think in that regard, it was helpful. The legislation from New York State, although modeled after the New York City legislation, is a little bit more bare bones. In my mind, leaves more questions. And so we're looking, in some instances, to the New York City legislation to try to fill in some of those gaps when there's a need to exercise some judgment on how to address an issue. So the accruals, we still have some time. There's still time to address this issue, but now's the time to do it for sure. But the accruals need to start at the end of next month, September 30. That's the effective date of the legislation. So by implication, the accruals need to begin then. And then the use of the actual time is not set to begin until the 1st of next year, 2021. And that's expressly in the statute as well. So some notable introductory points, and you may have heard me cover this before. It's a question that we get a lot, is, hey, does this only cover full-time employees? Does it cover part-time employees? What about our casual employees? What about temps that we employ, seasonal workers? So here, the legislation is going to be codified in Article 6 of the New York Labor Law. The actual statutory provision is going to be 196-B of the New York Labor Law, which is codified in Article 6. And Article 6 has its own definition section, which contains a very broad, somewhat circular definition of employee. It does not contain any exceptions for part-time employees, casual employees, student employees, seasonal employees, per diem employees. So as written now, and again, perhaps we'll see some clarification on this from New York State, but as written right now, the legislation is all-encompassing to cover all forms of employees. There's no minimum eligibility requirement in terms of hours worked or how long they've worked for the employer. If they are an employee, if we issue them a W-2, right, we consider them to be our employee, whether they're a temporary, casual, per diem, what have you, they're covered and potentially eligible for the leave. This legislation covers all private sector employers of all shapes and sizes, and there's no exception there. Notably, this because of where this statute will be codified in Article 6 of the New York Labor Law, it does not apply to public employers. The definition of employer for Article 6 exempts a governmental agency. The New York courts and federal courts interpreting New York law have interpreted that term governmental agency fairly broadly to include a wide myriad of public sector entities, including the NYPD, the Metropolitan Transportation Authority, and other public entities. Important to remember too, the legislation also expressly provides for job restoration. That upon completion of their paid sick leave, the employee needs to be returned to their same job. There are also non-discrimination and non-retaliation requirements in there. So as HR professionals, there's other professionals whose duties encompass human resources matters. Should a disciplinary or other personnel matter arise after somebody takes paid sick leave, we want to be sure that our antenna goes off, or that little red light goes off on our head that, hey, we need to be mindful and make sure we have our T's crossed and our I's dotted when it comes to those matters if somebody's coming off leave because of those protections. So how much time or what type of time that you need to provide under the new legislation will depend on your size. And for a small entity, it will depend on the amount of your net income. So we included this table just for frame of reference, but in short, the larger you are, the larger the amount of net income you have. If you're a small employer, the more leave time you need to provide. I will note two things. One, if you are a small employer with net income of less than $1 million, this doesn't exempt you wholesale from the leave requirement. It simply provides that you only have to provide unpaid leave, but you still have to provide that unpaid leave. A question we'll also get as well, I have more than 4 employees, but I'm still fairly small, and my net income at my organization or my business is less than $1 million. Am I covered? The way that the statute's written, that minimum net income requirement only applies to those entities with 4 or fewer employees. It does not on its face apply to, let's say, a 6-employee business that has a net income of less than 1 million. And so under a reading of the statute, again, our best reading now is that you would need to provide 40 hours of paid time to eligible employees. Also, a question we've gotten is how do I count the employees, right? How do I know what period of time should I use? What measure should I use? The legislation does not squarely address this. It just says that you need to count this in a calendar year. So you count the number of employees you had in a calendar year. Well, if we're starting, let's say, on this year in September, or we're counting January 1, 21 as a point in time when this goes into effect, when do we count? It seems one common sense approach would be to look at the prior year, since there is a 12-month period that can be measured there, and take a look at your head count at that point and determine if you have a sufficient number of employees and where you fall in that template there. With respect to accruals, again, as we mentioned, those accruals need to begin on September 30th of this year. That date is fast approaching. If you use the accrual method, the accrual works on a simple formula. It's 1 hour of paid sick leave that an employee accrues for every 30 hours of work. Again, no distinction made there between a part-time or full-time employee. It's just, hey, they get an hour of PSL for every 30 hours they work. Alternatively, an employer can elect to front-end load the amount of time that is required to be provided to employees. And we get questions, well, what do you mean by front-end load? Well, very simply, if I'm an employer and I need to provide 56 hours of paid sick leave time because of my size, then I would make that time available, that whole bank of time available to employees as of the 1st of January 2021. Right? That's front-end loaded, so they have that whole amount of time that they can use at any interval throughout the ensuing calendar year, including January 2. They could begin using that time right then. So one question that we've also gotten that is not settled in the legislation as well, I understand this time is accrual. Is there any cap on the accrual? Right? So I understand an employee needs to accrue 1 hour of paid sick leave for every 30 hours they work, but once they hit that maximum threshold of 40 or 56, is it capped and stopped at that point? The legislation does not address that. That seems to be a very common sense approach, since employees are only able to use 56 hours. As we'll talk about, there is a carryover requirement for any accrued unused time. But again, as an employer, we can set a limitation on the amount that's used in any year to whatever the maximum is, 40 or 56 hours. So again, to me, that's a common sense interpretation that the accrual would be capped there, but it's an open question right now. Perhaps we'll see some guidance on that. If you have questions on that specific issue, I encourage you to work with your legal counsel. So again, if an employee has any accrued unused time at the end of the calendar year, or if we're going to use a different 12-month period, as we can under the legislation to measure the benefit year, if they have any accrued unused time at the end of that period, we have to allow them to carry that time over. It's not optional. There's no payout option. It's to be carried over at the end of that 12-month period. And again, how much we have to allow them to carry over will depend on their size. So you see the two examples there. If you're under 100, it's 40 hours. If you're over 100 or 100 or more, it's 56 hours of time. Under the legislation, there's no requirement of payout at separation of employment. So that's a question we've gotten here. That's not to say an employer could pay that out at separation, but I think one cautionary point here, I would not necessarily just rely on the statutory provision for the basis that, hey, we don't have to pay this out to anybody. I would be very clear if the intent on your part is not to pay this amount of separation, to have very clear language in your policy making that point so that there's no uncertainty or confusion on that on the employee's part. Another question that's open at this time, but one we're certainly working with our clients to address as may be needed and continuing to evaluate is, well, what if, when does an employee get to accrue more time if they carried over time, right? So if I carry over a whole amount of my time, right, do I start accruing more time as soon as I use an hour of time or 4 hours of time, whatever's provided under the policy? That, again, makes sense to me that you wouldn't accrue any additional time until you've depleted that 56 hours below the maximum cap, but it's not settled or not clear in the legislation. As for use, again, use begins January 1 of 2021. The legislation does contain some definitions that we've included here. I don't want to go through them, but we wanted to, I try to avoid busy slides in general, but we wanted to give you some slides that have particular information. Just as a PS there, you should have received a communication from the firm providing you with access to these slides before the presentation began. We certainly will follow up with you afterwards and also provide access to these slides so that you have the ability to print out and keep this information. But here we have some definitions. I think it's notable that what's covered here, as we'll talk about in a second, are illnesses and injuries and health conditions or the need to have a diagnosis, but there's no definitions for any of those terms. Family member, parent, child, you'll see that is referenced in circumstances where leave can be used, and all of those terms are defined very broadly. But just keep those in mind for policy reasons. So there's really three buckets of what I would say time that can be used or circumstances when paid sick leave can be used. Just as a reminder, there's no minimum hours worked requirement or minimum period of time that an employee needs to work for the employer for them to be eligible to use paid sick leave, at least under the legislation. So again, it's unlike FMLA that we may be familiar with, where there's an hours worked and length period of time of employment requirement. That is not the case under the paid sick leave legislation. Again, employees are eligible to use this time as they accrue it, or it's front-end loaded for them, whatever is selected by the employer. But there's three buckets of time or circumstances when this can be used. Basically, if it's the employee's own mental or physical illness, injury or health condition, or that of a family member, keeping in mind that definition is very broad of who constitutes a family member here. On that first bucket, I think just something important to note is that they're allowed to take this leave for such an illness, injury, or health condition, regardless of whether or not at the time of the request there's any type of diagnosis or if there's any kind of medical care required, right? So it doesn't matter if they don't have a diagnosis. It doesn't matter if they're not intending to pursue treatment at that time. They're still eligible for the leave. The second bucket is where there's a need to have a diagnosis, care, or treatment of an illness, injury, or health condition on the employee's part or on the employee's family member's part. And finally, the paid sick leave can be used in circumstances where the employee or the employee's family member has been the victim of domestic violence, a family offense, a sexual offense, stalking, or human trafficking. And the legislation provides an enumerated list of circumstances when an employee would be eligible to use this. Most of these, I think from a common sense standpoint, flow from the circumstances where somebody's the victim of a domestic violence issue, a family offense, sexual offense, but the list is included there, so we wanted to give you that information as well on this slide. In terms of the use, the legislation does provide employers with flexibility to set the increments that for use of that leave, but it's important to note that it cannot be any larger than 4 hours at a time. So we can't require, if an employee needs to use paid sick leave, to have them use 8 hours each time. The largest amount that we can require them to use is 4 hours of the available time that they have. we can allow them to use smaller increments of an hour or 2 hours, but that's the smallest, the largest amount that we can require them to use. Just as an aside, there is a provision in there dealing with restrictions on employers from requiring employees, and I'm going to summarize this, but basically requiring them to provide us with any confidential information pertaining to their health or diagnosis of their health relating to their need for leave. So in our mind, this then raises a question of, well, what type of documentation, if any, can we provide validating the use for the leave? At the end of the day, given that there needs to be no specific diagnosis, at least in categories 1 and 2, or a desire to seek treatment of any kind, what we can require from the employee may ultimately be very limited. It could be a simple certification that they need the leave for one of the enumerated purposes, and that's it. Again, we're continuing to evaluate this issue as we get closer to January 1, 2021. We'll expect to continue to work with our clients to address those issues and to have plans in place on how to implement any appropriate documentation. So some special considerations here. There's a number of them, and I know Teresa has been very closely tracking these issues as well as kind of the general requirements that I just breezed through for you. Teresa, why don't you take us through some of these issues and your perspective on them?
All right, thank you, Andy, and thank you everyone for attending and hanging in with us this afternoon. This is a very dense topic, as Andy pointed out. So he took us through some of the more basic points, which I think are very important to consider as you're going through. And I'm going to go through some of what I'm dubbing the special considerations. And the first one is the thing I get the most questions on, which is employers' existing leave policies and what employers are supposed to do if they have an existing leave policy that either provides for vacation or paid time off or personal time or even sick time. Do they have to comply with the requirements of the new sick leave, and to what extent? So the statute doesn't give us much on that, but it does give us something. And it says an employer is not required to provide additional sick leave under the new law if the employer has adopted a sick leave policy or time off policy that provides employees with an amount of leave which meets or exceeds the requirements of this section and satisfies the accrual, carryover, and use requirements. So the way that we're interpreting that is if you have a PTO policy or some kind of paid time off policy or sick leave policy, you can use that to fulfill your sick leave requirements as set forth by this law, as long as your policy meets the accrual, carryover, and use requirements that Andy just went through. Those really are, when you're looking at your policies, the big three that you got to think about: accrual, carryover, and use. And if your policies meet those standards, then they are going to very likely suffice for paid sick leave. I will say I've been reviewing any number of these over the past couple of weeks and months. Most policies that allow for the accrual level or the correct amount of leave or above the amount of leave of PSL can be modified for carryover and use without too much difficulty. Okay, so the second one would be collective bargaining agreements. That's our second category of questions that I get a lot about that deviates a little bit from the basics. So under the statute, nothing in the law, so nothing in the paid sick leave law or anything that we just mentioned should be read to prohibit a CBA entered into on or after September 30th of 2020 from, in lieu of New York paid sick leave, providing a comparable benefit for bargaining unit employees in the form of paid days off, and such paid days off can be in the form of leave, compensation, other employee benefits, or some combination of those pay or benefits. And nothing in this law should be read to impede the ability of the parties to negotiate the terms and conditions of sick leave different from those in New York paid sick leave. But, and this is very important, if either of those options is exercised, the CBA must specifically acknowledge the provisions of New York paid sick leave to be codified at New York Labor Law Section 196B. So that's a lot. That's a lot of statutory language. Let me try to summarize that a little bit. So, in essence, what the statute is providing, or what we believe the statute is providing, is that if you have a CBA or you enter into a CBA and that CBA has paid days off or has extra compensation in lieu of paid days off or some combination of that, you do not need to comply with New York paid sick leave law as long as the CBA specifically acknowledges the provisions of New York paid sick leave law. And so that really becomes the question of what does must specifically acknowledge mean? Certainly that's something that we hope the guidance gives us more to work with there. At this point, I think employers need to be aware that if they have collective bargaining agreements that do not meet the paid sick leave requirements, they need to at least be thinking about how they might adapt those agreements to meet the paid sick leave requirements, and or reaching out to the collective bargaining representative for their employees and kind of getting a dialogue going about how they're going to work together to make sure the contract specifically acknowledges the provisions of New York paid sick leave. So hopefully more to come on that, but certainly if you are an employer with collective bargaining in place in your workplace, that's something you want to start thinking about sooner rather than later.
Teresa, before we go on, can we go back to the CBA provision just for a second?
Yeah, go right ahead.
Oh, thanks. I think this is a question that we got from quite a few people. And the New York City legislation, when it came out, quite clearly stated that it did not impact any current provisions under a collective bargaining agreement. The New York State legislation doesn't contain that same type of representation. If you'd agree with that, Teresa, correct me if I'm wrong, but it certainly makes clear that prospectively, right, you can have terms that differ. And I think what the state was doing with this is recognizing the give and take that may ultimately happen at the bargaining table, that the representative in the bargaining unit may wish to give up certain type of paid leave benefit in exchange for maybe a wage increase of some kind or some other type of tangible benefit that they prefer to have. And that parties can negotiate those different terms, certainly with a new contract. But then there's the other provision, right, that talks about nothing in this is meant to infringe the right of the parties to come together and collectively bargain different terms than what's provided under this. Again, paraphrasing there, but to me that raises a question as to the approach that we can take where we have a current agreement. It's not set to expire for some time. We do have leave provisions in there. They may not marry up precisely with what's required under the paid sick leave legislation. So what do we do in that situation? And we've been working with a number of our clients who have collective bargaining agreements in place. And what I would just tell you is you're going to want to work with legal counsel on that. There are some strategies that can be implemented that may prevent, kind of having to wholesale open up this issue with the union that you have in place. And furthermore, it's going to depend on a number of circumstances, right? What terms do we have in the labor contract? What type of flexibility do we have in there in terms of our management rights? What's the relationship like with the labor union? But I think we want to be careful in terms of how we broach that issue, if at all, with the union, if we're in a current contract. And I don't know if you have any other kind of thoughts over on that issue, Teresa.
No, I think that's a good summary. There's not a lot we can say about this other than what we've said, just because we don't have as much clarity as I'm sure we all wish we had. So turning now to other sick leave laws, this is another one of those things that you're going to be wanting to consider when you consider how to integrate paid sick leave into your employees' leave banks. So as you know, New York and the federal government have a number of other laws that may affect paid sick leave and how an employer decides to administer paid sick leave. And so I can't go through how each one of these interact with paid sick leave because we would be here for 3 days. But I just flag these so that you can be aware that when you're drafting your paid sick leave policy, that you may also have to add language about paid sick leave to these policies and vice versa, if to the extent they apply to your employees. So those are the federal emergency paid sick leave. We know that EPSL for COVID-19. Right along with it, the Expanded Family and Medical Leave Act for COVID-19. New York State has its own COVID-19 sick leave. Of course, we have New York State paid family leave and the FMLA. We have New York City paid sick and safe time, which Andy's been alluding to for our New York City employees, and then paid sick leave for federal contractors for those subject to that provision, and then paid sick leave in other states and cities. So I don't want to lose track of this. New York State is not the only state to implement paid sick leave, especially in states like California, Massachusetts. There's paid sick leave in specific cities and states throughout the country. So to the extent that you're operating in any other locations, you're going to want to check that out as well, so that you can make deliberate choices about how consistent you want to be in your policies. So policies, documentation requirements for policies. There is currently no requirement that an employer must have or distribute a New York paid sick leave policy. Unlike some of the laws that we've seen New York pass, where they've mandated that employers draft a policy and give the policy to the employees within a certain period of time, there is no requirement that an employer must have or distribute a New York paid sick leave policy. That being said, we expect and have seen that most employers will and should revise or draft their policies for their employees regarding paid sick leave and the integration of paid sick leave into their overall leave schedule. Policies, if they're going to be drafted, should be included in the employee handbook and should also be distributed to employees with assigned acknowledgement if they're not going to be in the handbook. Some considerations for your policies. These are just things I keep in mind when I'm reviewing people's policies or drafting new policies. You're going to want to consider the accrual, carryover, and use information. Those are the big three tenets that you'll want to look at first, because unless those are satisfied, the policy is not going to pass muster. You'll also want to include definitions of relevant terms, some of the ones that Andy went through that we have, such as family member, child, parent. You'll want to make sure those are defined in your sick leave policy, particularly if they differ in definition in that policy than they do in some of your other policies. Your policies should prohibit discrimination, harassment, and retaliation for employees who use the leave or make a complaint regarding the same. Your existing policies, even if they meet the hours requirements and the carryover requirements, should explicitly be modified to include the enumerated uses of the leave. So I'm just going to give a quick example of that. If you have a PTO policy that allows employees to carry over all of their accumulated hours and allows employees to have 100 hours of PTO every year, that policy will meet the accrual and carryover requirements, but it should still be modified to include the enumerated uses that Andy went through, just so your employees are aware that they can use this time specifically for the uses set forth by the paid sick leave law. The policies should also reflect other leave law policies, paid or unpaid, the ones I just mentioned, such as federal contractor, FMLA, New York paid family leave, collective bargaining agreements, and then those policies and agreements should be modified to reflect New York paid sick leave as well. I think sometimes when drafting policies, it can be tempting just to modify the one and not think about the others that interact with it and how they might themselves need to be modified. So I don't want anyone to lose track of that as they're going through the policies. Documentation is a very interesting point of this law. It goes along with policies. I know Andy mentioned it a little bit already, but the statute does provide that employers must track how much leave their employees have used and or accrued, not only for the current calendar year, but for any previous calendar year. So it's really quite broad in terms of the tracking and the amount of information that the employer must retain regarding their employees' paid sick leave. This information must be provided upon oral or written request of the employee within 3 days of the employee's request. Please note there, that is an oral or written request, so the employee does not have to write it down or submit any kind of special form or paperwork. Moreover, to the extent that human resources will be keeping track of this information, but employees are in the habit of asking their supervisors these types of questions, you're just going to want to make sure your supervisors or managers are trained to know that if they get asked this question, that they have an obligation to get the answer for the employee or to refer the employee to human resources so that they can get an answer within 3 days of the employee's request. Okay, so answering your questions. Thank you all so much for submitting your wonderful questions. Andy and I had quite a few confusing moments looking at them, but we managed to get a couple of them on the next slide. So we're just going to go back and forth and answer them as best as we can in our last couple of minutes here. So I'm going to take the first question, then I'm going to shoot one to Andy, and we're just going to go back and forth like that. So the first question is, will New York State Department of Labor publish any New York State paid leave guidance or regulations? They are supposed to under the statute. We hope that they will. The last we have heard from New York State is that the regulations or guidance are going to be arriving within the coming weeks. We have not seen anything more specific than that, but certainly stay tuned to our blog, and we will absolutely get an update on that as soon as we possibly can out to all of you. And then Andy, our next question is, will Governor Cuomo stay this legislation?
Yeah, another good question, Teresa, and one we've gotten a lot. And I'd be remiss in not mentioning here, again, we have questions, you have questions. I think we're almost up to 200 questions that have been submitted from our attendees here, which is great. Obviously, we're not going to be able to address all those, but what I'll commit to you and Teresa, if you're interested and available, we'll do a follow-up and we'll reach out to you again. We'll try to focus specifically on those issues that we think are of general interest, knowing that people now have some background information. So more to come on that. We'll set up another webinar where we can drill down into those issues and provide some more guidance for you.
Absolutely.
But this is our best sense of things right now. Again, a lot of this is fact sensitive and dependent. We're giving you our best thoughts and judgment at this time, but none of that should replace you speaking with your legal counsel and assessing these issues in your particular cases. My guess is no, is that this legislation won't be stayed. Of course, I could be wrong, but this is something that has been percolating on the state level for some time. I think it's something that the governor and his staff are very interested in advancing. Frankly, they brought it in as part of the budget when they had taken it out during the initial COVID pandemic phase. So I think it's here to stay. I think it's highly unlikely that we'll see this stayed. Teresa, another question we get is, hey, so if I front end load the 40 or 56 hours every year, so the employee is going to have their maximum amount available to them January 1 or whatever the benefit year that we pick, right, on that first date. Do we still have to track the carryover and allow them to carry this over?
That's a great question, and it's one I've gotten a lot. So the New York City law, which this is modeled after and which Andy has alluded to, does say that if you front load the leave, you don't have to allow for the carryover. The New York State law does not make that distinction. Perhaps they will in the guidance. They have not made it yet. So right now, carryover of the leave is very much still in effect, no matter whether the leave is front loaded or not. And then Andy, our next question is, how is the rate of pay defined for New York paid sick leave? I know this one's been on a lot of people's minds.
Yes, so there's no specific definition, but the legislation does say it needs to be paid at the employee's regular rate of pay. And for those of us who work in the wage and hour area, that's a term of art that has a particular meaning. Your regular rate of pay is, as a non-exempt employee, is not necessarily just your base hourly rate. There can be other forms of compensation that's provided to an employee. For example, a non-discretionary incentive payment that needs to be included, or a shift differential that needs to be included when computing the employee's regular rate, at least for overtime purposes. perhaps the state here meant your base hourly rate, but they didn't use that term. They used the term regular rate of pay, which can be construed to say that, you know, whatever you would normally include in that non-exempt employee's base rate of pay, or to determine their overtime, right? You also need to include that for purposes of determining what you're going to pay out for the paid sick leave. Again, this is another issue where hopefully we see some guidance and clarification on this, and we encourage you to work with your attorneys to figure out the correct approach for you. So one question we got, the employer provides paid time off already. The employee had access to this time during calendar year 2020. They used 56 hours of this time. Do I need to have them start accruing time come September 30th? Teresa,
and the answer to that is yes. Unless we get something in the guidance to the contrary, there is no provision in the statute that allows for an exception if the employee has already used 56 or 40 hours of PTO in 2020. They still get to accrue it or have it front loaded come January 1st, 2021. Okay, so Andy, our next question, how is leave to be front loaded or accrued for part-time or per diem employees? How does it work for those that are not full-time?
I was hoping you were going to get that question, Teresa.
Oh, okay.
I'll do it. So that's not, I'm kidding. There's no definition, there's no explanation of how do we accrue this, calculate this accrued time for a part-time employee, right? Whether they accrued or we front-end loaded. So if I get a part-time employee who, you know, works 1,040 hours, right, essentially half-time a full-time schedule 2080, right? Do they accrue the 1 hour for every 30 hours worked up to the 56 if that's my max threshold? Or because they're only scheduled to work half the amount of time, they can accrue up to half the 56 hours. It's not, you know, and likewise, right? If we front end load it, do we only have to front end load, in my example, half the 56 hours for the employee? To me, that makes sense. That makes perfect sense. Otherwise, you essentially put a part-time employee in a substantially better position, right, to have the equivalent of more time off for their hours worked than a full-time employee. Unfortunately, we don't have clear guidance on this. The legislation does not address it. You can construe it to say that, hey, a part-time employee gets up to the 56 hours. It's just going to take them longer, right, to accrue that than it would a full-time employee because they're only working half-time during the week. But that's one issue we're continuing to monitor, and I'd encourage you to work with your bond attorney to figure out what approach makes the right sense for your organization or business. So we saw, Teresa, in at least the FFCRA legislation, some exemptions for small businesses who may experience a hardship by providing either the emergency FMLA or the emergency paid sick leave, COVID leave. Is there anything like that in this legislation?
You know, unfortunately, there is not, other than the threshold split that Andy mentioned earlier. If you have 4 or fewer employees and your net income is less than $1 million, that would be the only division New York State has made on the basis of finances. Otherwise, there is no financial hardship exception for this law. It applies to all private employers. And that, speaking of who it applies to, Andy, are nonprofit making institutions covered?
Yes, I'd say they are. There's no, again, the definition of employer is very broad in Article 6, where this statute's going to be codified in the labor law. It does not contain any exemption for nonprofit making institutions. So the default there is that, yes, you are covered for this particular legislation. And just as a PS there, I think we mentioned in the prior slide that student employees are covered. Again, this is, I think, an issue for certainly a number of our higher education clients who are wondering, hey, do I have to cover our student employees with this? the New York City legislation did contain carve-outs, specific exemptions for students who are working at higher education institutions. The state legislation does not contain any carve-out. The definition of employee for Article 6 does not contain any such carve-out. Similarly, those of you might remember the Wage Theft Prevention Act and the notices that need to be provided to student employees. Again, whether a student is an employee is a separate issue that you need to evaluate, but if they are an employee, we are issuing them W-2s, then again, there's no exception for those students in the legislation. Maybe we'll see one in the regulations or guidance. All right, I think we covered how do I calculate an employee's rate of pay, correct, Teresa?
Agreed.
So what about this for overtime, right? Does paid sick leave count as hours worked?
Well, not that there's anything in the statute to state it, but no, generally speaking, only hours worked, actually worked, have to count for overtime, and paid sick leave would not meet that threshold. Okay, Andy, do I have to track usage time for exempt employees?
I think you do. You know, they're going to be eligible for this benefit. I think you're going to have to provide it to them upon demand. You're going to have to tell them how much time they've used and what they have available to them under the legislation. So I think the answer is yes here. And I say that recognizing that this could be not the easiest thing to implement, right? In many cases, you may have exempts who aren't tracking any type of time. Maybe they are tracking vacation time already, but I know many clients don't necessarily have their exempts tracked that as closely as need be for the non-exempt employees. Teresa, so what if I need to take leave because my child's school is closed due to COVID? Can I use PSL for that?
You know, that's a good question, and I think it really illustrates how much new legislation has been thrown at us in the past really 6 months, where people are starting to think, can I use, you know, what leave applies to what situation? You almost need a giant flow chart with multiple tabs to keep it all straight. You know, it's a lot to get all at once. Normally, paid sick leave would have been a topic for a year, right? But now it's essentially being smushed into a 2-month period just because we've had all of this around COVID. But to answer the underlying question, paid sick leave really should only be taken for a medical condition or for one of the safe time purposes, such as domestic violence, human trafficking. So I would say, generally speaking, no, it can't be taken for a child whose school is closed due to COVID-19. If the child has COVID-19, I think the answer would be different. Andy, anything to add to that one?
No, I think that makes sense. Yep.
All right, then, can an employer use the front-loading method for employees who are in one position and the accrual method for employees in another? Do they have to front-load for everybody, or can they do partial front-load, partial accrual?
So once again, the statute doesn't address it, but I think that would be okay. I don't see any prohibition in the statute allowing you to draw that distinction. A couple additional points on that, right? We always want to be mindful of how we're treating our employees. We want to do it fairly. We want to have a reasonable explanation if we're going to be treating them differently and keeping in mind, you know, this principle of fairness that's out there. Of course, it goes without saying that we must not discriminate against and provide benefits on any basis of somebody's protected characteristic in any way, shape, or form. We want to be able to show that the lines that we've drawn, of course, are legitimate and non-discriminatory. So another question we got, Teresa, is does an employer have to ensure that PSL leave is used for purposes enumerated by the law?
You know, this is a good question, and I think it actually dovetails nicely into the second bullet point, or the last question that we got. So I'm going to kind of give my thoughts on it, and then I'll turn it over to you, Andy, to address both of those too. Because the question really here is, do we have to make sure that if my employee calls and says, I'm taking 8 hours of time today for sick time, that they're actually using that for sick time purposes? And frankly, we just don't know the answer to that yet. Just me personally, I expect that if you give the employee the requisite amount of leave, or you allow them to accrue the requisite amount of leave under the statute, that you're not going to have to police the way that they use it. But certainly we hope that that's something we can get guidance on in the coming months. And to Andy's earlier point about documentation, how exactly do you ensure that PSL leave is used for purposes enumerated by the law? We don't have a strong sense of what types of documentation an employer can ask to even meet that threshold in the first place.
Yeah, to me, I feel like we should be able to, at least at some base level, be able to have an attorney, or excuse me, have an employee affirm or some way represent that they're using it for this purpose. I think we want to have some documentation process that can show it was used for this purpose specifically. So how we do that exactly, I think, is another question. It may just be something very simple, but again, I think in 99% of the cases, right, somebody's going to need this leave. They're going to be sick. They're going to have a family member who's sick. They're going to be going through something, and they're going to need this, and it's going to be entirely legitimate. But doing this job, I have seen cases where there are illegitimate uses of this leave, where there are misrepresentations made. The employee says, "Hey, I need to take paid sick leave because I got to care for a sick family member or injured family member," and then the next day there's some social media posting that you get that this person. I'm trying to think of a concert that we could go to, but no concerts these days. But right, you get a picture of the employee on social media at the concert, and leaves our head scratching as to the veracity of their original request. So the last question there, I think, gets at the heart of a lot of the questions that we've received to date, and including today. And it's figuring out, okay, how do we dovetail our current leave policies, right, and determine if what we provide is enough to satisfy the New York paid sick leave requirement. And once again, the legislation leaves some gaps. So here I look towards the New York City legislation. And the New York City legislation clearly says and has been interpreted that, hey, if I provide 100 hours of paid sick leave, of, let's say, generic paid time off that an employee can use for whatever purpose they want, including the enumerated uses for paid sick leave, that's good enough. Right? That's enough that I provide this, and they can use that time for paid sick leave. And I think the implicit notion being, if they use that 100 hours for some other reason, we don't have to supplement that with additional paid sick leave if they have one of these qualifying conditions. I would have liked the state legislation to include a representation to that effect. Hopefully we'll see something by way of guidance. But I think that's a common sense interpretation, right? So in other words, if we provide 120 hours of PTO time, we allow employees to use any amount of that time for any of the qualifying conditions under New York State paid sick leave. They use 100 hours, let's say, on vacation. That our obligation in that situation would be, hey, they get 20 more hours of leave that they could use towards those qualifying paid sick leave conditions, but we would not necessarily have an obligation to provide something beyond that. Again, that's me looking at this with a common sense approach and looking towards the New York City legislation, which was our model for some guidance here. But candidly, there's still some gaps, and I think you're going to want to evaluate this and how you approach this carefully with your attorneys. And just do we have? Is that the last question, Teresa?
That's the last one.
All right. So we did break the. I know we're up against the hour here. We apologize for going a little bit late. Folks have really stayed on though. So we did break the 200 question threshold. We will get back to you on this. Folks, please,
Oh my.
all I would ask is, this isn't the end of this issue. There are a lot of questions that are out there. We have time. I expect that we will get guidance at some point from the state that'll help us fill in these gaps. If we don't get that guidance, we're going to work with you to make good decisions, to evaluate the situation as best possible, and to get you to a point where you're comfortable and we have things on track towards compliance. This was the case with the FFCRA. There were a number of questions that we had when that legislation came out at first, and we worked with our clients diligently to try to fill in those gaps and make good decisions along the way. I think if we end up where we don't have that guidance, or if the guidance is waits until the 11th hour, we'll work with you to help make those decisions, make those judgment calls as best we can based on the information we have. So good luck to you in the meantime, Teresa. I don't know if you have anything else you want to offer in closing.
No, just thank you so much for your continued time and attention, not only to this issue, but to all the COVID issues. We truly appreciate it, not just this afternoon, but every afternoon and morning that you're able to join us. And as Andy said, more to come.
All right, take care, everybody. We'll see you.